So Eddie, come on up for just a second. So Eddie Williams is a person that works with me. He normally runs these meetings. I just happened to be here tonight, so I took the mic away from him. Eddie is a licensed real estate agent. He's an investor, and he's my personal insurance guy. He handles a bunch of different things for my wife and I when it comes to insurance investments, and he's a really good guy. And I'm going to let him take the meeting back over now.
All right, thanks, Mark. I'm also a wholesaler, so if anybody's looking to get on a buyer's list, although I am primarily metropolitan Detroit, so anywhere in the Detroit area, and you want to get on my buyer's list, feel free to give me a call or a text, 248-252-4114. Eddie Williams, 248-252-4114. Alrighty, the main reason that everyone came here tonight or tuned in via YouTube is to get some information about probate and how to get those properties through probate or out of probate. Before I get into that though, I just wanted to do a little plug for our meetings. We always have these meetings here the third Tuesday of every month. We bring in a different speaker to cover a different aspect of investment real estate. They're always third Tuesday of every month here at Shields Pizza in Southfield, Michigan at 7 p.m. and they are always free. All are welcome. Tonight we are deeply honored to have Miss Julie Pette here. She is a probate attorney with 16 years of experience. So without further ado, Attorney Pette, thank you very much.
Hi there, Julie Pette with Law Office of Julie Pette. A little bit about me, and yes, I do have notes to keep myself from going all over the place. I do have 16 years of experience as a probate attorney, and I own my own law firm. We are a 4-attorney firm. We primarily practice in the realm of wills, trusts, probate, related matters like that. We are located physically in Oakland County, but we serve clients statewide. So we're anywhere in Michigan. We have already handled cases in 51 Michigan probate courts, and we have a goal of getting into all 83 counties in Michigan, so we're working towards that. A little niche area that I've been involved in for about 10 years is working on dormant accounts, and that's where an account owner passes away and there's a bank account or a life insurance policy or something like that that never gets claimed, and then it goes dormant. It gets generally turned over to the state. We research those old accounts, and then we try to track down, create the family tree, track down the heirs. I'm an experienced genealogist, so we figure out who would be entitled to share in those accounts, and we try to go track them down and let them know that there's a little bit of money out there that they're entitled to. That work led into sort of a related area of working on surplus funds from foreclosures. So as you may or may not know, if you get foreclosed on, when the house is actually bid on, there may be a surplus. So there may be more money, in the value of the home than what is the debt that you're being foreclosed for. And a lot of people who are going through a foreclosure don't realize that they could actually have money coming back to them after their foreclosure. So we've just recently started working in that area, and that kind of has also led into us working with some real estate investors. And we've done a few different deals with real estate investors. For instance, many of you may be out door knocking, trying to find those good deals, maybe looking at pre-foreclosures, things like that. And one example is there was a real estate investor who was door knocking and located this family. The owner of the real estate had passed away, and the home was very soon going to be foreclosed on because the family just didn't know what to do. We got involved. We were able to stop the foreclosure, work with the bank, and then get probate open. We got the probate case open in a matter of days, and we were able to stop the foreclosure and basically save the family from all those fees of foreclosure. So that kind of work is basically what's led me here to you all. And I know from my experience with handling probate estates, there are just lots of homes sitting out there vacant after the owner passes away. The heirs don't do anything with the home. They maybe don't know what to do, or they can't handle the overwhelm. Maybe they're mourning the death of their parent, and then they've got this home. There's also a lot of misinformation out there, a lot of misunderstanding. One case that we were working on, the family let the home go through foreclosure because they were afraid that if they opened up a probate estate or if they did anything with their mother's estate, that they would then be liable personally for her debts. And that's not the case. And they actually, one of the kids in this case was so convinced of this and so dug in on this fact that there would be some kind of liability about this home, that even after it going through foreclosure and there being a foreclosure surplus, he still did not want to allow one of his siblings to handle the probate estate, to claim that money and get that money out for all of them, to benefit all of them, because he felt that he would be roped in and he would end up being personally liable for their mom's debts. I think another misunderstanding is people think, well, I don't have tons of money to pay attorney's fees, so I can't afford to do this. And they don't even look into it, don't even have a consult with an attorney or find out a little bit of information. You just make up these assumptions in your head and kind of go with that. And to me, that's really unfortunate, because especially in a market like this, it's a hot market. Homes typically have equity in them, and if these people could get more information about understanding that if there's equity in the home, that's probably just all benefit for you and the heirs. And so that's part of a mission now I'm on, is to try to educate the public about the options and demystify probate, especially real estate and probate. And so for a group like this, I would like to give you a little education on it, and maybe you don't know exactly what probate is or how it works, and maybe you have passed over deals because there could be probate involved, and I'm here to let you know, don't pass them up. We can still do deals. There's opportunities out there, and it can be a win-win for both the investor and the family. Okay, so a little background on what probate is. Basically, an executor is appointed by a judge, by the court, and that person will have the authority to administer the estate. So that typically involves collecting assets, maybe converting assets like real estate into cash, going around getting accounts, any liquid assets, collecting all that, maximizing the property and the assets for the benefit of creditors and the heirs or beneficiaries. So creditors, of course, they're gonna get paid and taken care of first. Doesn't necessarily mean they always get paid 100%, but creditors first, and then first administrative costs, like attorney's fees and court costs and things like that. Then creditors get satisfied, and then if there's money left, heirs and beneficiaries. There's two options with probate, either a supervised estate or an unsupervised estate, and typically that's the difference of whether you need to get court approval for everything. So unsupervised generally means the executor can go about taking care of the estate without coming into court and getting things approved by the judge first. There are some exceptions with that. Sometimes a court will allow you to have an unsupervised estate, but they might put in your court order appointing you that you don't have authority to sell the real estate. So even if it's unsupervised, sometimes you still have to go see the court or go see the judge with a deal. The purpose for putting that restriction, especially with real estate, why the court might allow you to handle the estate except for real estate, you have to come in if you're going to sell it, is to protect the estate. So obviously, cash, someone can walk off a lot more easily with a pile of cash than you can with a piece of real estate. So once you want to convert that real estate into cash, then the court may put further restrictions on what can be done with the money in the estate. But don't get skittish just because you hear you might have to go to the judge to get a deal approved. The process, if you do have to get court approval, is pretty easy. Basically, the attorney representing the executor drafts a petition asking for court approval of the sale, and will include, all the details of the sale, and attach the purchase agreement and probably comps, market comps. You don't have to have an appraisal. Sometimes you do have an appraisal, and some cases call for getting an appraisal, but it's generally not required to have an appraisal. If you have an agent or you can get good comps, that's going to be sufficient in most cases. When you would want to get an appraisal is if there's a fight over the value or about the sale of the real estate. So even if you have a case where the parties are fighting in the case, that doesn't necessarily mean you have to get an appraisal. It's really if there's some question about the value of this property, or if it's more of a unique piece of property and it's kind of harder to value. But for the most part, when we're talking about a decedent's residence, you're going to be able to get comps, and that should be sufficient, assuming that you're selling it for what it would be worth out on the open market. The petition that the attorney presents to the court is going to have basic facts, like I said, the deal itself, how much debt is left in the estate, and also it's going to know what the SEV is of the real estate. And that's a key component, because typically what the courts are looking for is for your sale price to be at least 2 times SEV. So I think most of us realize that's a pretty low bar to have, to get a deal that's at least in this market, in a nice robust market, it's going to be pretty easy to have a deal that's at least for 2 times SEV. And that's because that's pretty much what the court relies on when they are valuing real estate and probate. They're looking at the SEV. And it's just kind of, it's just kind of a constant metric that they can rely on and that they can use, and pretty much just accept that 2 times SEV is pretty close to fair market value. The judge is not really going through the agreement with a fine-tooth comb. Yes, they are reviewing the deal to make sure that it's beneficial to the estate, but it's not like they're going to sit there and nitpick each condition of the sale, and like you're negotiating with the estate, and then you're also negotiating with the judge too. It's really not like that. It's really not that complicated. Basically, you just need to give sufficient support to the judge to grant your request. And if you have, again, like if you have a realtor who can who can pull some comps on the MLS and provide that, that's generally sufficient. The realtor does not really need to come to the hearing and testify. I've seen attorneys bring the listing agent in to give testimony at the hearing, and I've never done that, and I've never had an issue where the court required that. And the realtor, the attorney should work with the realtor before the hearing to be sufficiently prepared for the hearing. So the realtor can explain market conditions, explain any possible issues or drawbacks with this particular property that might make it less marketable, and help explain the price that the estate has agreed upon. If it's maybe a little bit lower than market value, definitely good communication with the realtor can help the attorney go into court and be well prepared. But like I said, the bottom line is the judge is going to be looking at whether this deal benefits the estate. What benefits the estate is to convert this piece of real estate into cash so that, again, administration costs can be paid, debts can be paid off, and the heirs can get their share. Our approach at my office, I feel like we do a really good job handling real estate and probate. Our main focuses are reducing costs to the estate, getting to closing as soon as possible, and avoiding hearings unless necessary. We don't file a petition for approval of real estate unless we're required to, or unless we think there's a really good reason. For instance, like I said, the parties are making some kind of arguments that this is a shady deal or it's not a good deal. If they're making a lot of complaining, okay, yes, you might want to ask the court for the court's blessing on the deal. But otherwise, we kind of avoid going to court if possible. If it's an unsupervised estate, that's just going to drive up costs for the estate. And it's just a wild card you don't want to bring in. If you have a sound deal, you should just be able to go ahead. And the executor has that authority. They've been given that authority by the court to make these kinds of decisions. They were able to show that they're trustworthy and that they're the appropriate person to make these kinds of judgment calls. So that's their job. We try to reduce the hearing. We have a really strong focus on getting to closing as soon as possible. Like I said, we feel that it's really important not to lose a buyer. You don't want to lose a deal. You don't want time to be stretched out so long that the buyer walks. That's not going to benefit the estate. So we try to get the petition filed very quickly. After filing the petition, typically the court will assign you a hearing date. That's usually, it's about 6 weeks out. It can be 2 or 3 months if there's a lot of backlog. But it's usually about 6 weeks out. And something that I learned early on, which I just because I was naive, and I was like, oh my gosh, 6 weeks, but we're supposed to close in 30 days. So I complained I expressed to the clerk, like, oh my gosh, what are we gonna do? And I learned that you could just go to Chambers and ask for a better date. And wow, yeah, we get one. We've gotten one every time. So we just accept whatever court date we get assigned, and then we go down to Chambers and we ask for a date 3 weeks out, which is kind of the minimum you can do for notice purposes. You could do less. You could actually have less time than that if everybody is cooperating. So that's another option, is if you get everybody to sign off and say, yeah, I agree to this. You could even do it in less than 3 weeks. We also try to anticipate what the title company is going to require for the closing. So we try to have all of our ducks in a row and have all that ahead of time. And we've been through it enough times that we think we pretty much know what's going to be needed for closing day. And then some title companies, after your hearing, some title companies say that they won't close for 21 days because there's a 21-day appeal period after a hearing. So they'll say, okay, well, we can set closing out for 3 weeks. And again, that's an extra 3 weeks on the weeks it's already taken to get to this point. And again, we're trying to get to closing. We're trying to get the deal done. So we've been successful in most cases, either asking them, hey, can we talk with your legal? Or can you pass this information on to your legal? Or we can go back sometimes and get documents signed by the parties in the case, and that sometimes satisfies the title company. But basically, we just, we try whatever we can. We're trying to be solution focused and figure out a way around that. Some of the things that we see out there from other attorneys, how they kind of muck it up a little bit. Some attorneys They just want the court's blessing on everything, which I kind of understand. If you're very nervous and afraid of what you're doing, or maybe you're unsure of what you're doing, I can see running into court all the time and asking for the court to give you a court order saying it's okay to do that. But that's very unnecessary, and that's really not how probate is designed. It's really not meant for you to have to go in front of the judge for everything. Also, some attorneys open a probate case on a petition, which means you have to have a hearing in front of the court. And especially in Wayne County, I don't really understand why, but if you open on a hearing in front of the judge, you are going to be restricted on your real estate. There's an option to open a probate estate without going to the court, and it's called an informal opening, and that's typically what I prefer. And one of the big reasons is then you're not going to have the restriction on sale of real estate. So again, unless there's a reason to go to court and ask for a hearing, like if there's some question about if the will is valid or if there's already fighting or something like that, yeah, you might need to have a hearing. But other than that, a lot of times it's really better to do it without the hearing. And again, it's less cost to the estate, and you're not going to have that restriction on selling real estate. Some examples of why you really don't need to go in and be nervous and ask for the court's blessing is if the real estate was listed on the MLS and it's been listed, for a reasonable amount of time, and you've gotten the best deal that's come in, I would say that's pretty safe. Again, assuming it's at least 2 times SCB. If you're in a robust market and you're going to have a good deal and it's going to be profitable for the estate, again, you don't have to be too nervous. Or if the offer is near or close to or above the comps, you're pretty good. Also, if there's one heir and you're not required to get probate court approval, I definitely do not think you need to do that. But even if there's a large family, there's multiple heirs or multiple beneficiaries, again, that's if everyone is, on the same page, there's good harmony in the family, I don't think you should go to court and ask for a court order on your deal because it's really not necessary. So anyway, this is just kind of an introduction to probate and some of the issues we see in real estate with probate. Again, I think it's a shame we see all these vacant homes out there, and you would be surprised how many vacant homes somebody's sitting there paying the real estate taxes year after year. I think because they don't want to lose the home, but what purpose does that serve, having an empty home on the block just sitting there? So I personally would love to see these homes sold and have them put to use, maybe have a family move in there. Again, convert that asset into money check for the heirs who are entitled to it. And sometimes people are heirs and they don't even realize it, or they don't even know that there's a home that's available that could be sold and converted into cash for them. So it's a great market out there. So if you come across any deals where the owner on title is deceased, don't pass it up. That can be a great opportunity. Those are great homes for flippers. They usually need a little updating, maybe some renovations. The family probably doesn't want to take their own cash and pour it into fixing up the home. So there's great opportunity there for you all to make a good profit on it, and also, make it a win-win and make it a good deal for the family. And I'm happy if anybody wants to talk more in depth about probate, come talk to me. I'll talk all night about it. Thanks for your attention. Oh, yeah, my phone number is 248-648-1148. We have a website too, paquettelaw.com. It's PAQUETTE law.com.
Do you have any questions?
Can you repeat the number one more time, please?
Sure. It's 248-648-1148. And if you found any value in this conversation, I would love to be referred to come out to anybody's office and explain probate itself or real estate probate. We're trying to get more speaking engagements. Thank you. Yep, it's Julie Pette, and it's Law Office of Julie A. Pette, and we have a Facebook page too, and we would love more likes. Yeah.
So the household probate is the executor able to perform any repairs or updates to the proper course of things?
All right, so the question was, if there's real estate in probate, is the executor able to do updates or repairs or whatnot to the home? And the answer is yes. They certainly have the authority to do that. It has to be to the benefit of the estate. Typically, when you're improving real estate in a good market, it is going to be a benefit, but where does the cash come from? So if there is not cash in the estate, again, a lot of times the family members don't want to use up their own cash to make those improvements. But if there is money in the estate, then yes, and that's a judgment call that the executor needs to make. Is it better, if there's this bank account here, there's plenty of cash, should we use that to improve the real estate? Or is it better sell it faster, as is, and get what you can on it? And that's usually what most people do.
So the homes that you find that are going through probate are usually listed in legal news only primarily, or is there other avenues of finding these homes where probate is?
Okay, the question is about how to locate homes that are going through probate, and is it in the legal news or other avenues? The legal news is not necessarily going to tell you that there's real estate in a probate case. There is a requirement to publish. If someone died within the last 3 years and you're opening their estate, there is a requirement to publish notice in the legal news for creditors. But it doesn't say in there, that notice is not going to say, and we own real estate. It's not going to indicate that. How best to find deals? In my opinion, it's a lot of hustle. You could look at the court records. There are a lot of the probate courts have court records online. Again, it's not necessarily going to tell you that there's real estate. There's key little clues that I kind of know to look for. But door knocking, foreclosure notices. I think sometimes foreclosure notices will say estate of. I'm not sure, but.
Thank you.
The probate deals that I've found has basically been from door knocking, or I get a call from somebody that wants to sell the house, and they say that my mom died. But they don't realize they got a probate.
Right.
So then we explain that to them, and then we'll contact the probate attorney for them.
Yeah. So Mark was saying that his deals, they come to him from door knocking, or a child or a family member will reach out and say, hey, I need to sell mom's home. And that brings up a point that we see. Sometimes people have the misunderstanding that if they are nominated in a will to serve as the executor, that doesn't give them the authority. That does not put them in at that job. You have to go to court and be appointed by the court. So that's just a nomination. That's just the decedent saying, when I die, this is the person I want to be in charge of things. So you do not have authority to list the home or sell the home just because the will says you're going to be the executor. You've got to go open probate. In a trust, it's a little bit different. A trust instrument does give you that authority without having to go to court, but not in a will. And we see that where people, sometimes the realtor doesn't realize they need to figure out if this person actually has the authority to sell this house or not, and they'll list it with someone who's not actually in a position to sell the real estate.
So now I've got a situation where I find somebody that's inherited the home, or it hasn't been probated, and the person who died has income, or has assets, other assets the total assets are probably less than 25,000, and they can do a fast probate on it. Can you tell us about that?
There are some shortcut procedures in probate. So what I was talking about basically was a full probate where you're going to be appointed by the court. You've got to work through all these steps. It takes at least 5 months. Typically, it's about a year. And that said, just because a probate case might take a year doesn't mean that you would have to wait a year to sell the home. You could sell the home immediately as soon as you get appointed, but you might not be able to distribute the estate until later. You've got to wait for certain periods and figure out the debts and everything, like I was saying. What Mark is referencing is these shortcut procedures, and sometimes you can do like a 1 day, same day probate procedure, even for real estate if it's under a certain threshold, and that's typically like $20,000 to $40,000. Those are rare, but it is something that can be done. I would say it's most often when there is not real estate in the estate, because usually real estate is worth substantially more than $25,000. But sometimes that happens, and there are some options and shortcuts.
So the best deals I've got in real estate have been when somebody tells me that the house needs to be probated, and what that means is I've got lots of time. As a general rule, I've got a lot more time than somebody that wants to sell a house and have it gone in a week. They want cash now, where I can fully say, yes, I can do this. It needs to be probated. So it's bought me the time to do whatever I need to do for your finances. That's a major advantage of probate.
So Mark was saying one of the advantages of doing real estate investing with probate properties is it gives you a little time. So the parties understand that there's a little bit of time involved, a little bit of waiting. They're not expecting you to close with cash next week or something really fast. They understand, and there is a process. There are some times you can go and get probate open and get your executor appointed the same day. That is definitely an option that we use a lot, but generally there is some waiting and a little bit of time involved. But that said, like I said earlier, we've gone on in and gotten probate open real fast, kind of emergency situation to stop a foreclosure. Other reasons, there are emergencies. Sometimes you can go in and get appointed immediately, even if you don't meet the requirements to have that same day appointment. You can go in on an emergency basis for different reasons. Okay,
Just
thank
quick.
you. Yes.
What's the best way to find these probate deals?
The best way to find the properties?
I know these probate. I know some people, they're at the courthouses.
It's door knocking.
That's best, the way.
Probably marketing yourself so that people who have, their parents pass away and they have a piece of real estate, they know who to call. But yeah, door knocking, vacant properties,
What was the question?
He was asking what's the best way to find.
Some of these people go to the courthouses, I was told, and they do these searches, and I just didn't understand that whole process.
Yeah, I personally don't know how you would do high volume searching of the court records. I know you could go to court and look through the files, but I don't know if there's some kind of crawling software, or that's not something I know.
The question was?
The question was how to find probate properties. Okay. Yes?
All right, before you step down, I just have a couple questions for you. All right, so this one's for wholesalers. Wholesalers a lot of time will find a deal and it has to go through probate. Instead of just waiting till the people go through probate and hoping that they come back to us with the deal, can we establish a relationship with you and say, I will have my probate attorney call you, and that way it will get through probate a lot quicker?
Okay, so you can definitely refer people to us. We would not be representing, I mean, we might be representing the investor depending on the situation, but we probably would be ultimately representing the executor. So yes, you could absolutely tell these, tell your prospective client and our prospective client, hey, this needs to go through probate, and we know a great probate law firm we can connect you to. Would you like to talk to them? If they say yes, then we can talk to them.
Okay, all right, cool. Okay, all right, now, I don't want to put you on the spot, but I'm going to. Would your firm be open if the heirs don't have the funds? Would your firm be open to waiting until after probate and the wholesaler has sold the property to collect your fee?
In certain cases, yes. For the most part, at my office, we will not take on a probate case on the promise of being paid later. We will require a retainer, especially in the case of someone, calling us up. I found you on Google, my dad passed away and I need to handle the probate case. I have no assurance that I'm going to get paid or something isn't going to go sideways with my relationship with the client, and I do not want to be chasing people down for fees. But when it comes to working with investors, people who are doing this on a regular basis, there's definitely more possibility to talk there because I have more confidence that there's going to be a sale quickly, there's going to be cash available, and sometimes there's cash in the estate, and that can put me in a much more secure position too, if there's like a bank account or something like that.
Can the investor pay your fees?
Yeah, the investor can pay our fees. That does not change our ethical duty. Our relationship is still with the executor or whoever it is that we're representing, but we can take payment from a third party. But we would definitely go through that and explain what that means, and that we have no duty to the person who's paying our fees. We cannot discuss things with you. Our duty is to the client, the person that we're representing.
All right, one last question. This is for a friend of mine who couldn't be here, and she wanted me to ask you this question. Her neighbor passed away, found her deceased there in the house after a time, and she wants to get that house. And so since this just happened within the last month or so, what is the best way for her to inquire and find out about the house, which is, I don't even know if it's going through probate yet?
There's a lot of different options or ways to look at that. I think the best, most direct thing would be to figure out who the heirs are and reach out to them. And you obviously would want to know, is there equity in the home? Are the taxes up to date? If it's in jeopardy of going to tax foreclosure soon, that's obviously a critical situation. And there is a way to open a probate estate as a creditor. So there are possible options or creative solutions, but the most secure way would be to talk with the heirs. And like I said, I can help find them because I'm an experienced genealogist, and I'm pretty good at tracking people down. But yeah, there's some different ways to go about it, and there's a few different things to consider depending on the specific circumstances.
All right, can you contact information this one last time?
248-648-1148, and again, it's Julie Pette, Law Office of Julie A. Pette. Thank you.
All right, thank you very much. All right, anyone else? All right, once again, as a reminder, we always have our real estate investor meetings right here. We bring in a different speaker every month to cover a different aspect of investment real estate. Third Tuesday of every month at 7 p.m. right here at Shields Pizza in Southfield at Telegraph and 10 Mile. Thank you all for attending, and hope to see you next month at our free investor real estate training. Thank you.